Well, good afternoon. Last month, the Supreme Court issued its decision in Loper Bright versus Raimondo and Relentless versus Raimondo, major cases on the courts, regulators, and the rule of law. 4 decades ago, when the courts decided Chevron versus Natural Resources Defense Council, it was, intentionally or not, a watershed moment, changing the ways that courts, agencies, presidents, and Congress all went about their work. It also shaped the way we think about those institutions. The full effect of Chevron deference in each of those institutions would not become clear for many years. So too, perhaps, with Loper Bright. Some of its effects will be immediate and obvious, but some of its effects may not become evident for years. Still, it's not too soon to start thinking seriously about it, and not just Loper Bright's effects on the courts. In fact, today, our main focus is on the Constitution's other institutions, on Loper Bright's hydraulic effects in Congress and in the executive branch. And for this, we're lucky to be joined today by today's speakers, including friends from the Brookings Institution and Senator Pat Toomey, who will start the day in a conversation with my colleague Yuval Levin. Welcome, Senator Toomey.
Thank you very much for that, Adam, and thanks to all of you for being here. I shouldn't admit that I'm shocked that this many people are interested in this subject, but it's wonderful to see. And thank you to our friends at Brookings for hosting this with us today. On its face, you know, the Loper Bright decision and the overturning of Chevron is about the courts and is about the administrative state and the executive agencies. But almost every observer of this case is focused in one way or another on some of its implications for Congress, on what this rebalancing of how the meaning of statutes is interpreted might mean for the people who write statutes and for the people who are charged with oversight of how they're carried out. We're going to hear in a little bit from a panel of scholars of this subject, people who study Congress, but we wanted to start this afternoon with a conversation with someone with some experience as a practitioner and not just an observer of Congress. And I should say our plan had been to have 2 of them, to have a Democrat and a Republican here, and former Senator Heidi Heitkamp of North Dakota was all set to join us, and then had a flight cancellation. She wanted me to pass along that she's very sorry to miss this, and also that if we ever want to have an event on FAA reform, she would love to join, as someone who counts on flights out of North Dakota regularly. Yeah. And we're very sorry to miss the chance to learn from her, but we're very fortunate to have with us former Senator Pat Toomey of Pennsylvania to get his perspective as a former legislator who was very involved in working with the administrative agencies in a variety of ways. Pat Toomey was a member of Congress for 18 years, 6 of them in the House, 12 in the Senate. He represented Pennsylvania's 15th district in the House from 1998 through 2004. And then represented Pennsylvania in the Senate from 2010 until 2022. So he has really experienced the 21st century Congress from the inside. His focus as a member, I think it's fair to say, was maybe especially on economic policy. He served on the Budget Committee, on the Finance Committee, on the Joint Economic Committee, and maybe most notably on the Senate Banking Committee, where he rose to be the ranking Republican. A role that certainly put him very regularly into contact with the financial regulators, maybe not always in the most pleasant ways, but always in ways that reflect on the subject we're taking up today, the question of the role of the agencies and their relationship to Congress. And so it gives him a perspective that I think we all can learn from as we start to think about this subject. Senator Toomey, first of all, just thank you very much for being here. We're grateful. There are a lot of places we could start, but maybe the place to really jump in is the sort of perplexing reality that both Adam and I, in a way, began with, which is that the overturning of Chevron might be thought to be especially relevant to the courts and the administrative agencies, and yet there's a general sense that it will have real significance for Congress. And I want to start by just asking you whether the sense that some people have, the optimistic sense that I think a lot of people here have, that maybe this could be a way for the courts to pressure Congress to do its job differently or better, to write less vague legislation, to think a little more concretely about its role at the center of our system. Is that actually a plausible expectation from your point of view from this case? What do you think the implications for Congress really are likely to be?
Well, first of all, thanks for having me. It's great to be back. Yeah, I wouldn't be extremely optimistic in the short run that this will have a profound effect on Congress. Although over time, I remain an optimist that there will be more and better product produced by Congress. But I should say that in my judgment, the problem that Loper fixes isn't a problem of legislation that's too vague or ambiguous or otherwise inadequate. In my view, in recent years, especially with this administration, we have agencies whose leaders have decided they've got an agenda that they're pursuing. They're not there to impartially implement the laws that pertain to their jurisdiction. Rather, they're there to implement a particular agenda. They hire very capable, very creative attorneys to go out and justify somehow what it is that they want to do. And I think that's true at the FTC. I think that's true at the CFPB. I think that's been true at the SEC. And so they discover some power that no one previously had discovered in authorizing legislation, and they say, there you go, that's what authorizes me, in the case of Lena Khan, maybe to be extremely hostile to consolidation and to develop these theories that even vertical integration that's not harmful to consumers should somehow be restricted. And the list goes on with the other regulators. My theory is when you have agency leadership that are exceeding their legal authorities, it's particularly unreasonable to also empower them to be the adjudicator of whether or not they're exceeding their authorities. How do you think they're going to decide, right? And the Chevron deference largely allowed them to both implement these sometimes, I think, very creatively justified rules, and then be the judge that decides whether or not they did it properly. So what I like about the Loper decision is, in my view, this really restores the proper role of the judiciary in deciding legal matters, right? This has not really been controversial in the US since Marbury versus Madison, and yet we gave this deference to the agencies, and so for Congress to take, for the courts to take it back with respect to legal disputes, I think just makes a lot of sense. Does Congress respond to that opportunity per se? I think that could go both ways, right? One of the things, Congress might feel like it has a little less to worry about vague language, right? Because it'll be harder for the agencies to exploit it. I think Congress has other bigger problems, and hopefully we'll address that. But in the short run, I wouldn't expect a big change in behavior in Congress. I do think the agencies will start to change their behavior. I think they'll be a little less ambitious in this regard.
So I certainly want to talk about those other bigger problems too, but that tells a story that that takes for granted Congress as playing its role. But if we look at the relationship between the branches, you might say it's not surprising that the executive branch is assertive, energetic. The framers of the Constitution certainly expected everybody to be assertive and energetic. Right. The courts have been assertive and energetic in their own way for a long time, and maybe that way is changing some. But Congress has not been assertive and energetic. You say the agencies are taking liberties. Congress could do something about that. Yeah. Congress could take actions when it doesn't approve of what they're doing. How do you think about the peculiar kind of passivity, or is that not right? Is that
No, I think you're exactly right, and I've been criticizing Congress about this for some time now. Congress has willfully ceded its own responsibilities, abrogating its constitutional responsibilities in many ways to the executive, and then even when those powers have been abused, Congress refuses to step in. I'll give an example that I was very bent out of shape about when I was in the Senate. You know, the Constitution is completely unambiguous. It's Congress that has responsibility to regulate trade among the nations. Now, Congress delegates certain powers to the executive. As a practical matter, some of those make sense. One of them is the section, it's referred to as Section 232 of our trade law, that authorizes a president to impose restrictions, with quotas or tariffs, if national security requires it in his judgment. Well, under the Trump administration, we saw the very promiscuous use of 232 to justify tariffs, which had nothing to do with national security. I mean, the former president didn't even really pretend it did. It was about coercing trading partners to come to the table and renegotiate agreements that he didn't like. So if a president, so think about this, right? Congress has granted some of its authority to the president, at least with regard to national security. Then that granting of authority gets blatantly abused, and Congress sits there and does nothing about it. So I had a bill that I introduced, and I got a decent number of co-sponsors, fortunately on both sides of the aisle, it took a while, that would say something very simple. Say, if a president wishes to exercise the powers of Section 232 and impose trade restrictions because our national security requires it, then he needs to make the case before Congress and needs to have an affirmative vote of Congress to be able to go ahead. Now, if there's a real national security threat, why wouldn't Congress go ahead and grant the president that authority? But I got a decent number of co-sponsors, I don't remember the exact number, but it was never close to being able to get this passed. And so I think that's illustrative of this problem of Congress not just ceding authority, but not even imposing the discipline on the limitations of that authority. So I think you're absolutely right. And that's part of the reason why I don't think we're going to see a significant change of behavior in the short run.
And so how do you understand the sources of that problem? Why aren't members jealous of their power?
Yeah, that's a great question, and I have wrestled with it. I think it varies from member to member and at different times and under different circumstances. But I think ultimately it's a political judgment that's being made by members of Congress, and roughly speaking, the judgment is that if I avoid taking a controversial position, I'm less vulnerable to attack in my next re-election. So my perception on how dramatically this evolved in the relatively recent past arises from my own experience, right? When I first got to the Senate, obviously I hadn't known the Senate prior to that, but I did know the House. When I first got to the Senate, I thought it was functioning pretty well. So I was elected in 2010, so January of 2011. Harry Reid was the majority leader. And the routine experience, as I recall it, was on a Monday afternoon, he would introduce a bill. It would be open for amendment. Members would go down to the floor over the course of the next day or two and offer, in total, it would be several hundred amendments. And then there'd be a process of winnowing that down and getting people to agree that they didn't really require a vote on all of them. We'd get it down to maybe 20 or 30. And on Thursday afternoons, we would mow down 20 or 30 votes on substantive amendments that would really amount to a litigation of different policy preferences. We'd discover where the consensus was, and then we'd go on to passage. So that worked that way, I think, for the better part of that Congress. But at some point, Senator Reid felt it's very, very important that we not expose vulnerable senators who are up for re-election to having to cast tough votes. And so he started to block the opportunity to offer amendments. And that, sadly, it's amazing how quickly the Senate culture flipped from a culture that held that it was an outrageous offense to block one of your colleagues from getting a vote on his or her amendment, to a culture where you routinely block all amendments. And this suits the purposes of those who wish to be protected from controversial votes. I really think that's a big contributing driver of this.
So thinking about how that could relate to the question of the relation between Congress and the regulatory agencies, there have certainly been a lot of Republicans in Congress willing to express outrage at the actions of some of the regulators, the administrative agencies, they've often organized their arguments around the necessity for Congress to assert itself. There's been a move among Republicans in the last more than 10 years now to argue for something like the REINS Act, which would give Congress a much greater role in overseeing major regulations. Do I take you to be suggesting that they don't actually want that?
Many don't. So first of all, I'm a huge fan of the REINS Act. I think it simply restores.
Tell us a little bit about what it would do.
Yeah, so the idea is that Congress passes its laws, the various relevant agencies promulgate their rules under the APA, but before the rule goes into effect, it requires an affirmative vote by Congress. Now, this is the elegant solution here is that it restores accountability to basically the legislative process. I mean, we call it rulemaking, but let's be honest. Compliance with these rules is not voluntary, right? You have to comply as though it's a statute. And so, my reading of the Constitution is that all legislative power is vested in the Congress. Well then, at a minimum, you ought to have this rulemaking require the affirmative action of Congress. And then the American people can hold Congress accountable. If it doesn't like the rule, it can take that out on its member of Congress, as well it should. But what do you do when the EPA overreaches on the Clean Water Act? Or when the SEC decides it's going to try to prevent a whole new technology like blockchain from even being able to take hold. And the list goes on and on. There ought to be accountability. And so that's what the REINS Act really does. In my view, it restores the accountability that should be an inherent part of a democratic republic. But your point that maybe people aren't always as enthusiastic as you might. First of all, our Democratic colleagues are pretty uniformly opposed to any kind of congressional review of.
And how do you understand why?
I think they see it as a check on expanding regulation, and many of them really want the government to play a much bigger role in controlling the economy. And so they want the agencies to be able to regulate relatively freely. And of course, Republicans are kind of skeptical about that. So there's a practical policy reason why we come down on different sides. I would like to think that I would be in favor of this even if I didn't want to have less aggressive regulators, because I like the accountability that it offers. Last point I'll make is there was, I thought, a great opportunity to try to narrowly apply the REINS Act concept. And that was in 2018, you may recall, there was a big broadening of the powers of CFIUS, right? CFIUS is the multi-agency committee that is empowered to restrict foreign ownership of certain American assets, right? Most people don't think the Chinese government should own Raytheon, for instance, right? So CFIUS exists to sort that out. Well, the idea was maybe we should also restrict the ability of Americans to invest in overseas companies that might have some ambitions that are not good for the United States. Okay, so that's the concept. The statute itself, the legislation, granted enormous discretion to the Treasury in particular to promulgate the rules by which they would implement this. And I've made the argument that you may have a good idea here. There may be circumstances in which we don't want Americans investing and facilitating the development of something that could be a weapon system that could threaten us, for instance. But I could also see this going way too far and limiting capital flows and doing it for reasons that might not really be about national security. So how about we go ahead and let Treasury promulgate its rules that implement this new version of CFIUS. But before they go into effect, it comes back to Congress and we have to have an up or down vote. Expedited, I think it was simple majority in the Senate, so couldn't even use the 60 vote threshold that is typical. Every Democrat voted no, and 13 Republicans voted no. I had a majority of the Republicans,
Some of
but
the
13 voted no.
sponsors of the REINS Act voted no, right?
It appears that way. I was disappointed, but it illustrates the difficulty of getting Congress to take this kind of responsibility.
Did they tell you why they voted no?
Some did. I'd rather not get into a specific private
Fair
conversations.
Fair enough. So what would it actually look like for Congress to take that kind of active role in overseeing regulations? Is the institution even equipped to do that? Does it have the staff? Does it have the expertise, the time? How would its work have to change?
Right. So that's the question, and that's one of the arguments often suggested by the opponents, that Congress just doesn't have the expertise. The economy is complicated. You need experts to write this stuff. Here's my reaction to that. First of all, these rules very commonly apply to hundreds of billions of dollars worth of economic activity, hundreds of thousands, sometimes millions of Americans who are expected to comply with it. Well, if millions of Americans are expected to understand this well enough that they have to comply with it under pain of serious penalty if they don't, why do we think Congress can't figure this out? And by the way, as you know, Yuval, in the process of developing legislation, one of the standard things that every member of Congress does is we seek what we call technical assistance, TA. It has an acronym, it's so common. You go to the agencies that are likely to be affected by your legislation. You say, here's what I want to do. Here's the draft language we've come up with. Give us your feedback. Tell us, does this work? Is this problematic? Will it have unintended consequences? So that's an iterative process that we go through already. What would happen in my mind if the agencies knew that their rulemaking, that work product, would not be effective unless and until Congress voted in the affirmative, they would start from the beginning working with members of Congress, right, with the staffs, and it would be an iterative process because they would know that they needed the buy-in. Also, Congress does often write quite technical language. There's people with tremendous expertise that they're willing to share that with Congress, and so I'm very skeptical about the idea that Congress couldn't play the function of reviewing the rulemaking that Americans have to comply with. Would it take some time? Yes, because you'd have just the sheer time of having to vote on a lot of rulemakings. But I think most versions of the REINS Act contemplate that by creating a streamlined, facilitated process so you could get on the floor quickly, get the vote done, and be done with it. So those are legitimate concerns, but I think they can really be addressed.
How do you think about some of the other ideas that are out there for reining in some of the administrative power of the agencies? Things like a regulatory budget. Does that make sense to you?
Oh, absolutely, right? I mean, one of the other unambiguous items in the Constitution, of which there are many, is that funds aren't supposed to be appropriated without an act of Congress. And yet these agencies, many of them, they have budgets that come from totally other sources. When a regulator or an agency leader knows that Congress has no control over his or her budget, at least not through the appropriation process, I guarantee you that changes their attitude about how much they care about what Congress thinks. And I experienced that firsthand many times in the oversight responsibility that the Banking Committee had over the financial regulators. They would come in and testify if they had to, but it was often pretty clear that they really didn't care what we thought, because what were we going to do about it? That's a terrible, undemocratic system.
You were in the Senate when the Congressional Review Act, which allows Congress to have some oversight over rules enacted at the end of a presidential administration, came to be used to an unusual degree for a while. What did you walk away with about the usefulness of the Congressional Review Act as a model for Congress's role here?
Well, I think it's a constructive small measure, right? But as you point out, it applies very seldom, right? It really only applies with regard to legislation that's passed at the end of administration, and as a practical matter, when the incoming administration and Congress is controlled by the other party. And that's because the way the statute is written, there's a window of time. The only rulemaking that is subject to being repealed by the Congressional Review Act had to pass within a certain number of months from the time that the CRA is implemented. So I'm in favor of it to the extent that it does provide Congress with a mechanism, a somewhat expedited mechanism for reviewing and rejecting regulations that Congress disagrees with. I just think that should be sort of universally applied, and it should be flipped around the other way around. So not that the rule goes into effect and Congress can choose to repeal it, but rather the rule does not go into effect until Congress affirmatively validates it.
Tell us a little bit about the way that the administrative agencies look to a senior legislator. You were the ranking Republican on the Senate Banking Committee, and so you had a lot of dealings with the financial regulators. What's that relationship like? How do the agencies think about Congress? How do members think about the agencies?
I'm not sure I can generalize very well, Yuval. It varied certainly from agency to agency. Some of it is driven by the personality of the member. I will say I think there used to be a greater culture across the agencies of not wanting the rulemaking to be overturned by the courts because that was seen as you got it wrong, right? You got the law wrong. I think sometimes now there's a view that if you're not getting overturned by the courts, you're not trying hard enough. And really, and that kind of manifests itself in the relationship with Congress as well. And if Congress doesn't have direct control over the budget of the agency, Congress has no power to fire these folks. So it's a very indirect kind of accountability, and I think it's inappropriately little accountability.
You suggested at the beginning that the problem isn't really vague legislation, that that's not really what's going on. Does that mean also that there's not really a role for the courts in improving the functioning of Congress? The courts do seem in their decisions in administrative law now to constantly imply that if only Congress did its job, we wouldn't have to deal with this. Are they just frustrated with their own jobs,
No.
or are they right?
And I'm not suggesting that Congress isn't guilty of passing legislation that is too vague and too, broadly empowering of agencies. That definitely happens. But I'm just making the point that I think the more egregious problem is agencies that are intentionally trying to discover powers that really are not intended, are not in the statute. And that's what the Loper decision is going to change. Are judges at times frustrated by statutes that are ambiguous? I'm sure they are, and probably justifiably. But I just think overly ambitious agencies are a bigger problem.
You suggested too that some of the problems that Congress confronts now in getting its job done in a way that the agencies could be more responsive to has to do with the structure of how the work of Congress has changed. The rules, maybe particularly of the Senate, the character of Congress's work and schedule. Is that where change needs to happen? If it's not coming from the courts, how should the Senate be different in order to be more functional?
Yeah, I think that's a really important idea. And my theory on this is that the Senate, well, it's a fact that the Senate still operates mostly under rules that are very old. And these rules worked pretty well when the Senate had a different culture. So the most obvious example goes back to the point I made earlier. When it was understood that you would never block a colleague's opportunity to have a vote. You might disagree vociferously. You might be willing to move heaven and earth to defeat the amendment. But it wouldn't even occur to you to deny your colleague the opportunity to have the amendment. Well, fast forward to a period of greater polarization, and now you are not deemed to be sufficiently opposed to a policy unless you prevent even the consideration of that amendment to some degree. So one of the rules that I think has to change is the rule that governs whether and under what circumstances you can offer an amendment, right? Amendments are like the heart and soul of legislating, right? That is where you get a chance to litigate substantive policy differences. And under Senate rules, of course, an amendment does not have to be germane, which I think is a great thing. I know a lot of people intuitively think that it all should be closely tied to the subject at hand. I think being freed from that restriction gives you much greater opportunity to discover where a consensus may be on any number of things. But as you may or may not know, under Senate rules, a single senator can block consideration of an amendment under almost all circumstances. So you think about, if I have a controversial idea that I want to have litigated on the Senate floor in the form of an amendment, I need the 99 other senators to agree to allow me to have that vote. And let me tell you, that does not happen, right? So I think given the change in culture, it's reasonable to have a change in the rule. And my suggestion, and I made this suggestion in my farewell address to the Senate, how about we raise the threshold required to block consideration of amendment to some number greater than 1? I'm open to suggestion on what that number should be. Should it be 20? Should it be 40? Should it be 50? I'm not sure. But I just don't think 1 is the right number. And that one change, I think it could have a profound difference. If all of a sudden all kinds of amendments were being considered routinely, then Congress would be just so much more active. Members would have the incentive to do an awful lot more work because they would know they'd be able to get a vote on whatever it is they wanted to have a vote on. I'm not suggesting that's a panacea, but I think it would be an important step in the right direction.
Give members more of a reason to act as legislators.
Right. And also to get used to the fact that, you know what, I'm a U.S. Senator, I'm going to be accountable for votes, and I'm going to have to cast tough votes. And if you're going to have to cast tough votes anyway, maybe you wouldn't be so worried about voting on a rulemaking that was recently passed.
So as we get toward the end of our time here, I wonder if I could ask you a question as not a legislator, but in your work now, in your post-Congress work, as working in the private sector, how do you think about the terrain of regulatory challenges? What are the big issues, especially in financial services, which you know best, which you know very well? What are the kinds of regulatory challenges that are over the horizon? The kinds of questions that people who think about regulation and legislation are going to need to be thinking about 5, 10 years from now that might not be obvious to us?
Well, I suppose the answer to that varies a lot depending on exactly where you're sitting, right, and what's coming at you. So I wear a lot of hats. I'm on several boards. I'm an advisor to several different companies. One significant, it's not the majority, but a significant portion of my time and energy is devoted to advising folks who are in the blockchain technology space, crypto technology. I think it's a fascinating advancement that is going to make major changes to our economy over time. Right now, we have no legislation at all that governs how this space ought to be regulated. There have been efforts by certain members of the administration to pressure banks not to provide services to anyone who's in this space. They have no authority to do that, but they've got the power because they're powerful regulators. We have the SEC that is taking a really completely unreasonable position of accusing everyone who hosts trading in crypto tokens, virtually everyone, violating securities law because they say they're all securities. And when you call the chairman before the banking committee and say, well, tell me exactly which tokens are securities and why, and he refuses to answer the question, that's pretty unreasonable. I bring this up in part because, you can't put technology back in the bottle, right? It's out. And the world is going to develop this technology. And the question really is just, does it happen in America? Do we retain our leadership? Or do we end up losing that position? Does the dollar develop these technological capabilities that blockchain can enable it? Or do other currencies around the world have those features and we just don't? Those are I think, are important issues, admittedly in one sort of narrow space, but the complete absence of legislation leaves regulators to compete for the power to regulate it, and we're doing a lot of harm to a really innovative new space.
So, a final question. You mentioned the absence of legislation. do you think there's going to be a will in Congress to restrict the power of administrative agencies in the executive branch if Congress and the president are both in Republican hands next year?
So that's, I'm not optimistic. No, no. And I think, frankly, that was part of the reason why my Reins-type amendment on CFIUS failed. It was a Republican administration. And there were Republican senators who said, well, I don't know that I want to apply this to our own side. It's not about which side, it's about which branch of government, has legislative authority. So I'm not extremely optimistic. I would hope so, but that's going to be a tough hill to climb.
Senator Pat Toomey, thank you very much for
Thanks for
getting
having
us
me.
started.
Thank you.
Appreciate it. All right, everybody. We're going to get started with the next part of our gathering, which will consist of two panels of experts on the implications of the Loper decision. First, implications for Congress, and then for the administrative agencies. These will both be moderated by Katie Dunn-Tempest from Brookings. Let me just tell you a word about Katie and the important work that she's doing and turn things over to her. But I'll also let you know that if you're watching us online and you want to ask questions of these panels, you can certainly do so. You can do so by email or through Twitter. You can do that by following the instructions you would find right next to where you're watching online. There's an email address there and a hashtag to use if you want to tweet questions at us. We're very open to those, and Katie will put those to the panelists at the end of each of these panels. Katie Dunn-Tempest is a scholar of the presidency, very interested in staffing of the White House and the executive branch. She's published a huge amount on these questions, including the important book, Presidents as Candidates, Inside the White House for the Presidential Campaign. She's a senior fellow at UVA's Miller Center. She's a fellow at the Center for Presidential Transitions at the Partnership for Public Service. And she's the director of the new Katzmann Institute at Brookings, which is co-hosting this event with us. The Katzmann Initiative is named in honor of the late Judge Robert Katzmann, who was a friend to many of us here at AEI, too. He was a political scientist and a senior fellow at Brookings for many years, from the 1980s through the end of the 90s, and then was nominated to the Second Circuit and eventually became his chief judge in 2013. He passed away much too soon in 2021. And a large part of his research at Brookings focused on improving interbranch relations and the functioning of the separation of powers, a body of work that certainly connects very nicely to the topic of this conversation. So we're really thrilled to host this together with the Katzmann Initiative. And with that, Katie, I'll turn it to you.
Thank you very much for inviting me today and inviting the Katzmann Initiative to co-sponsor this event. A post-Chevron role for Congress is top of mind for many digesting the new Supreme Court opinion. How will Congress respond in the wake of this opinion? Will they work to pass less ambiguous laws? Will the institution strengthen its expertise by establishing new entities or strengthening committee staff? Will things remain the same? These are tough questions that require informed speculation. Fortunately, here with us today are three exceptionally well-known congressional scholars who can help us seek answers to these difficult questions. Molly Reynolds is a senior fellow in governance studies at Brookings. She studies Congress with an emphasis on how congressional rules and procedure affect domestic policy outcomes. She is the author of the book, Exceptions to the Rule: The Politics of Filibuster Limitations in the U.S. Senate, which explores creation, use, and consequences of the budget reconciliation process and other procedures that prevent filibusters in the U.S. Senate. Current research projects include work on congressional reform and the congressional budget process. She also supervises the maintenance of Vital Statistics on Congress, Brookings' long-running resource on the first branch of government. Kevin Kosar, he is a senior fellow at the American Enterprise Institute here, where he studies Congress, the administrative state, election reform, and the U.S. Postal Service. He edits the website, understandingcongress.org, and he also hosts a podcast for that website. He has a strong interest in thinking and writing about how Congress can bolster its capacity to engage in regulatory policymaking. Perhaps most interestingly, he has authored 2 books on the global history of whiskey and moonshine. Phil Wallach. Phil is also a senior fellow here at AEI and the author of Why Congress? No question mark. We'll talk about that later. Published by Oxford University Press in 2023. He is an expert on America's separation of powers, particularly the relationship between Congress and the administrative state. Along with his colleague, Kevin Kosar, he is the author of The Case for a Congressional Regulation Office. So let's get started. And I think before we dive into Loper's perceived impact on Congress, it's worthwhile to think about how we got here. So I'm going to start with Molly, who can give us sort of a nice historical overview to tell us how we got to this place in history. Molly?
Sure. Thanks, Katie. And thanks very much to our friends at AEI for hosting us today. I think the most helpful thing here is to start by asking ourselves, why do we get situations where Congress writes ambiguous laws in the first place? Because I think understanding what can come next requires understanding sort of these underlying circumstances. So one answer is that Congress simply lacks the expertise to write laws at any real degree of specificity. And so even if they wanted to, they are at present simply unable to. It is certainly true, all three of us have written about this, that internal congressional expertise, both in the form of committee staff and other nonpartisan sources of expertise in the support agencies, has declined in recent decades. So if you think this is the biggest explanation for how we got here, then the fix is straightforward, if not politically easy, which is just invest more money, more resources in Congress's in-house expertise, sort of let that expertise work its will. I also want to make sure we have two other ideas on the table. The first is the notion that ambiguity is sometimes necessary to build the political compromises that you need in order to pass legislation. You simply can't, in some situations, write more detailed laws. If you tried to do so, you simply could not pass them. The dissenters in Loper Bright acknowledge this. They write that ambiguous text often, quote, represents the limits of Congress's bargaining capacity. You could argue, I think Phil has done so, that we've reached a point where there's some sort of learned helplessness on the part of Congress here, in terms of Congress sort of throwing up its hands and giving in to gridlock because they know that agencies will step in to fill the void. It's hard to change the incentives that have produced this equilibrium, but it's, I suppose, possible. It's sort of a second point to make. And then the last idea I want to raise about how we got here is maybe the thorniest one, which is that even a well-resourced, non-gridlocked Congress, simply by virtue of the principal agent problems inherent in having separate entities write and implement laws, could not preempt every possible source of statutory ambiguity. I think the inevitability of some amount of ambiguity is important for this conversation, because one thing that the majority opinion in Loper Bright also does is really solidify a world where it's the courts that step in to adjudicate this ambiguity. So Roberts writes in the majority opinion, quote, agencies have no special competence in resolving statutory ambiguities, courts do. So I think this suggests that we should also be thinking about this decision, not just in the context of the power of the legislative branch, but also in terms of the power of the courts and how that has changed over time.
It's really helpful. Thank you for that broad overview. So Kevin, let me turn to you. The Katzmann initiative is really focused on interbranch relations, primarily reducing the tension between courts and Congress. What is the likelihood that this Supreme Court decision will affect the status of interbranch relations? And if so, in what respect?
Yeah, it's, I wish I knew. I wish I knew. I begin from the proposition that we have three branches of government and they inevitably contend for power to one degree or another. And the decisions here, Loper and Relentless, have kind of created an opportunity for power grabbing. Courts, they're going to have a greater responsibility to parse what did Congress intend with the statute? What did they mean? It's a different sort of review when they're faced with a case involving a rule. Prima facie, you might say, well, that means you have to pay closer attention to Congress. On the other hand, ultimately, it's the court's decision. Then you turn it over to the question of, well, what about Congress? And that's where it's really open. Is this a moment when Congress is going to lean in and try to claw back some authority? Or is it just going to keep doing as it's doing, in which case then power is going to slide over to the third branch of government. And I should say that both branches are probably going to find the future challenging. And if you'll indulge me for a sec, let's get prosaic, let's get real about regulation. This was in today's Federal Register. Federal Housing Administration Single-Family Sale Program, a proposed rule by Housing and Urban Development. This is the mere summary, which I'll give you a part of. In a single-family sale, the program, eligible single-family mortgage loans insured by the Federal Housing Administration are assigned to the Secretary of the Department of Housing and Urban Development. In exchange for claim payments, and mortgage notes are then sold without FHA insurance to qualified purchasers. The man seeks to maximize recoveries and strengthen the HUD's mutual mortgage insurance fund to achieve HUD's operational goals for the MLIF. Policy is exceedingly complex. This notice goes on for more than 20 pages. Judges are not trained to be experts in these narrow fields. Legislators are inherently amateur. Certainly over time, they can develop deep expertise, and many of them do. But this stuff is tough. And for either branch to be able to wade into it in a competent manner, there's going to have to be a good deal of thinking about their own capacities and skills and abilities.
That is a great lead-in to Phil's question.
Good.
So thank you for that, and thank you for the show and tell with the regulation. That was helpful. Phil, I think the ball is clearly in Congress's court to rise to the occasion. What can they actually do to heighten statutory clarity? Doesn't specificity in lawmaking cut to the heart of their ability to compromise, as Molly mentioned? Can you talk a little bit about maybe like reasonable short-term and long-term goals that Congress could have, and like just tangibly, what can they do?
Okay, great. Thanks for the question, Katie. And I just wanted to say to start, it's really a pleasure to be working with you and the Katzmann Initiative. I really admired Judge Katzmann a lot. He was a very profound scholar of how the law really operates in practice and of statutory interpretation. And he was just such a gracious person. So it's really a pleasure for us to be working with you and remembering him. So let me get to your question. So I want to give one big clarification first, which is that Loper Bright is not a non-delegation opinion, right? The majority opinion by Chief Justice Roberts does not say Congress can never delegate anything. Whatever words it uses are up to the courts to define what that's going to mean in terms of policy. No, but it says that we should be a little wary of this default expectation that anything ambiguous means that Congress meant for the agencies to be the ones to work it out. If Congress intentionally delegates, then okay. Then it's leaving some policy-making discretion to the agencies, and they're the ones who will make the decisions, and courts will say, okay, that's your job. Congress gave you that job, okay. So I think, the ideal scenario moving forward is that Congress takes that to heart and says, okay, when we want the agency to delegate, we need to be clear about what is our delegation, what is the limit of the delegation. Let's make that crystal clear right in the statutory language. That still leaves room for leaving some scope for agencies, which means we don't know exactly what the practical meaning of the law is going to be. It's going to vary from a Democrat administration to a Republican administration. That still allows some room for compromise of the kind that both Senator Toomey and Molly talked about. So I think that's possible. Now, that requires a fair amount of circumspection on Congress's part, though, right? It requires them being fairly deliberate about that. And frankly, it requires them to focus on their jobs as legislators and to be changing the laws such that they can be putting these careful delegations in. It means they can't just coast, and they can't just shake their fists at the agencies and say, Loper Bright, as if that's going to suddenly change how our government operates. I think you've started to see a little bit of that kind of reaction in the short term, as if suddenly, with this decision in hand, the administrative state must just be on its heels. I don't think that's right. Chief Justice Roberts said that Loper Bright does not overturn all the cases where Chevron was used. We're looking forward, not backward. And for it to be impactful, it really does depend on whether Congress asserts the control that is its constitutional prerogatives.
Yep. So I have a question now that I'd like all three of you to answer the same question. Molly, you first. Tell me, what's the buzz on Capitol Hill? I'm just thinking with your research and your endeavors that you and the people that you know day to day, what's the buzz on Capitol Hill? What are they thinking about? And if you had to pick one priority for Congress at this moment, what should the institution do?
Sure. So I think at this point, a lot of folks on the Hill are in a very sort of real and practical sense asking themselves, okay, what do we do next? How, if at all, do we change our approach to legislative drafting, given the current levels of capacity, including in places like the Legislative Counsel's office? What are changes that we can make immediately? I also think that folks are trying to assess which policy areas are most likely to feel the effects of this change first. I say that because while we all sit around having these big conversations about the balance of power between the branches, a lot of congressional staff are very motivated by policy outcomes in the particular areas that are of interest to their bosses, what they care most about. We know that in relation to action by agencies, all policy areas aren't created equal, including, and very relevant for this conversation, in the degree to which near-term regulatory goals may or may not rely on existing ambiguous statutes. So there are certainly some places where I think folks might have things that they would have wanted to try to do, where this decision may have more of an impact than others. And Phil just mentioned the point in the majority opinion about the fact that existing decisions, previous cases that relied on Chevron are still subject to statutory stare decisis. I think we'll see sort of how exactly that plays out in the future, what might get revisited, what that could look like. In terms of priorities, I'll say that I am skeptical that increased congressional capacity is sufficient to ensure that Congress is empowered in the face of this decision, but it's probably a necessary condition for doing so. We know there are a lot of political challenges to bolstering Congress's capacity. Again, the three of us have worked on this question in different ways for quite some time. But if I were to have a magic wand that I could wave, I think that's the first place where I would focus.
Is capacity building?
Yeah.
Okay, great. Kevin, what about you? Do you want me to repeat the question?
No, I think I got it. If I don't, just throw something. Buzz on Capitol Hill. Well, to a degree, I think what we're hearing from Capitol Hill is a little bit of the longstanding refrains from both parties, which Senator Toomey kind of hinted at. First, there's some Democrats who are aghast at what the Supreme Court did and who are denouncing it and who are worrying aloud about the death of the regulation and how everything is going to be terrible, terrible, terrible for the average American as predatory corporations are turned loose. Meanwhile, on the right, we have some folks who are kind of licking their chops and imagining that the administrative state has been slayed and that regulations can start going away and that freedom will blossom. It's not a particularly helpful conversation, but it's a long-standing conversation. Getting people to talk reasonably about regulatory reform or regulatory legislation of any sort has been extraordinarily difficult for a long time. There's just been this bad dynamic of the conversation being driven by the extremes. Fortunately, there are people in Congress who are serious about the topic, who realize that this is an opportunity, and also don't just see this as a partisan issue. They see this as a legitimate governing matter and do see Congress as having some responsibility. And they may even see some opportunities, whether it's for their own desire to make policy or otherwise, in doing something. And I can't share the name of which committee, but there is one committee next week that's actually holding a topic on this very issue of Congress post-Chevron, a committee hearing. So there'll be a discussion, which is a very, very helpful sign. But like I hinted at when I read this, only part of this summary, regulation is a very tough thing. And if Congress is going to move it into its workflow, well, guess what? Congress's workflow right now is already kind of spilling over. If you have a contracted congressional calendar when you're only in Tuesdays through Thursdays, House committee staff, there are fewer House committee staff than there were in the 1980s. Legislative branch support agencies are, less populous than they were 40 years ago, yet the expanse of government is so much greater. If you're going to lean in on legislation, you're going to need help, because again, you can't just pick this up and spitball it. It takes a lot of education, thinking, expertise, and there's just not enough of it on Capitol Hill. And as any congressional staffer will tell you, they don't need anything more added to their work plate. They are plenty busy. So I would echo Molly that congressional capacity has to be, bolstering it has to be part of the conversation around enabling the legislature to lean in and to take this opportunity to reclaim some legislative authority that's dribbled away or been given away over the years. And with Phil, some years back, he was the lead author on a piece, or I was second fiddle, where we argued for a congressional regulation office, which is analogous to the Congressional Budget Office. But if Phil wants to speak more of that, go right ahead.
So Kevin, would your number one priority be the same as Molly, which is sort of internal capacity building and figuring out ways to manage this?
Yeah, it's got to be a capacity building thing, and I really think you need to think of this as work. I mean, these are human beings that got desks and papers, and they have time allotted to stuff, and the congressmen and their staff are run hither and thither. I mean, they're pulled in a lot of different directions, and how do you graft into this work, which is substantial? I mean, we're talking a few thousand major rules every single, a few thousand rules every single year being proposed, and then moving towards completion. That's a lot to cover.
But I don't mean to be sarcastic or, sort of disrespectful, but maybe we need to work more than Tuesday through Thursday in Washington, D.C.
Well, that's part of the capacity. That's part of the capacity job. It's time on task. It's incentives for doing the work. It's the expertise in-house, better technology. I mean, who knows? AI could work here as a way of helping go through this heavy sort of stuff and try to see where regulations conflict with each other and all that sort of stuff. There's many possibilities. They have to think big on Capitol Hill.
Yeah. Phil, what about you?
Well, I spent the morning looking over just what people are saying about the decision, and I think, Democrats are just saying how bad it is mostly. Haven't really seen much in the way of what should be done about it. Republicans in the House sort of went on a letter-writing blitz. This is their strategy, coordinated through the Majority Leader's office. He put out a statement saying, agencies can't be allowed to run free without any checks on their power. We've already seen how frequently federal agencies will abuse their power. We intend to ensure agencies are held accountable following the court's ruling and observe the proper checks on their power. And basically, the approach is to send out letters and say, hey, now that Chevron is gone, you better go back and look at what you did and fix it. Because we know you were getting away with murder before, and now you got to go back and clean up your act. Well, the spirit of that is wrong, Congress. Sorry, because they're not going to do it. One, maybe you don't really expect them to do it. Maybe the saber rattling is just for its own sake. But really, the thing we need most is for Congress to realize that it's on them to shoulder their constitutional prerogatives. And there's such a tendency for legislators, when they want something done, to write a letter to the executive branch and say, I'm a congressman, listen to me, go do this with your executive branch authority. And even this, where we say you've been abusing your executive branch authority, the reaction is, you go fix it, executive branch. Sorry, Congress has to take it upon itself to fix it. So I'm a big capacity enthusiast, but I really see it as the first priority is to rekindle a sense of institutional pride on Capitol Hill. I really think that has suffered in our polarized age. I can see why legislators think of themselves as partisans first and as office seekers first. Some of that's eternal, some of that's specific to our age, but they really have to think of themselves as holders of the powers of the purse, which is a profound power, I think I agree very strongly with Senator Toomey that when Congress gives away its power of the purse by setting things on autopilot, it really diminishes itself.
Yeah.
And it should think about how to change its habits in that regard.
Yeah.
And it's also, Congress is the one that ultimately controls what's in the US Code. And that's ultimately the power to determine what the federal government spends its time and energy on. So it doesn't happen by accident. You can't just say, well, I think you're using the Clean Air Act wrong, let me shake my fist some more about it. Well, go ahead and rewrite the act.
Right, and be more specific about what you wanted, yeah. To what extent do you think that the permanent campaign, which is this term that's bandied about mostly amongst academics, but this notion that ever since the 1980s, members of Congress in the House, they are constantly running for re-election. It used to be that senators would have a pause where they could pause raising money shortly during that first year they were elected. But basically, it's sort of this money race. They're constantly raising money. They're focused on their re-election campaign. Many of them are running on campaign platforms that are anti-government. So this notion that you're then going to sort of take charge of lawmaking and be specific and work with agencies in a much more collaborative way, it just seems we're so far down the road on the permanent campaign that to do anything in the first place, you have to figure out a way to kind of reverse that whole mentality. Am I wrong? Or it's like, I care a lot about campaigns and elections, so I might be overemphasizing that aspect of a member of Congress's life, but it seems like that plays a big role.
I mean, I'll take a stab at that. Ultimately, accountability to the voters is a good thing. That's what gives Congress its legitimacy. That's why it's the first branch, is that it's fundamentally the closest to the people. But yeah, to the extent that this campaigning activity and this fundraising activity crowds out everything else, it's just hollowing out the institution. So I don't think members really like it. They feel like they're caught in an arms race and they don't have any other choice.
Yeah.
And of course, their party leaders often encourage that mentality because they care about the money and building up the war chest for the next election. But I think we should try to work with members to say, how could we put in at least some ceasefire measures to say, let's give you more of a protected time to do your work as legislators.
Yeah.
So I'm in favor of trying to bar fundraising activity during work hours. I think we should explore ways of allowing members on both sides of the aisle to just back away from this time. A former member said members of the House have become glorified telemarketers. Well, they didn't sign up for that job. That's not what they were hoping for when they ran for office,
right,
and had big ideas about how they could serve the American people. So they want to change things. If we have to work with them, and sometimes against the grain of how things are today, to help them affect the change.
And Molly, would that kind of change have to be orchestrated by leadership? Or are you just hoping that there's a few members of Congress who have enough personal clout that they can encourage their fellow congresspersons to do the same?
Yeah, I mean, I think some of this comes back to one of the things that Senator Toomey was talking about on the first panel, which is this notion of taking tough votes. And so we've reached a point in kind of the macro competition in our political system where each election cycle, the battle for control of the House and the Senate really sits in the hands of a small number of districts and states nationwide, and that the structure of the legislative agenda, particularly around sort of specifically what is being voted on, can be driven in large part by a concern for the electoral fortunes of those members. And so you have sort of the majority leadership thinking about how to protect their vulnerable members. You have the minority leadership thinking about what are the tools of the legislative process that we can use to try and force votes on things that might embarrass the vulnerable members of the other party. And so that, I think, to this point about, we want Congress to be more active, to do more legislating, that sort of incentive loop is really hard to get out of. And so I don't know that it's an either or question in terms of what would it take to solve it. It would take sort of everyone thinking that it was worth being solved. I don't know that that's where we are. And because I do think that kind of the world that we live in is the product of the incentives that our current members face.
Interesting. And Kevin, Senator Toomey was talking about, you're advocating actually for this idea that members of Congress should vote on every regulation after it's been created by an agency. There should be sort of a second vote. They vote for the law and then they vote for the regulation after it's been formulated. And you also were just talking about how those who work on the Hill, their plates are heaping. You know, they've got so much going on. The notion of that many more votes, how does that work?
Yeah. The formulations of the REINS Act that have been out there, I mean, this has been around for years and years, would try to force Congress to take votes on the real big regulations, not the little teeny ones that, you know, here's a rule announcing that a certain park is going to be closed for a certain number of hours, you know, that sort of little piddly stuff. It's the big stuff. Yeah, that's a kind of procedural device to force Congress to take up some responsibility that it's, you know, shunned or just simply fallen away from thinking about actively. And it's a ways to force legislators out of this unhealthy dynamic, which what they frequently do is they let the executive branch make policy decisions, and then if they like them, they cheer. If they don't like them, they hoot at them. And then you get somebody who's in the White House who decides to switch regulations on certain topics, like immigration, for example. And again, there's cheers from some, hoots from other. Inevitably, there's a court case. That's what happens when legislative power seeps away from the legislative branch. You seldom get a healthy resolution of a tough issue. Of course, if you're going to have votes on the major rules, and maybe there's only, you know, few dozen of them a year, that's still a few dozen more votes. And members may not be highly incentivized to vote on them. And it raises the question of, well, if they don't put it on the calendar, does just nothing happen? And I think the answer is, yeah, nothing happens. So where does that leave the agency? Well, it's in a weird limbo where presumably it's going to go back and create a new regulation, which could be substantially similar, or they could try to break it up into pieces and therefore get it under the limit and work it through. There's nothing wrong with the REINS Act. I've written in some praise for it, but it's complicated, and it's also just a question of, you know, how do you vote on some super complex rule like the one I started to read to you all if you don't really get it? Are you going to vote particularly well? Wouldn't it be nice if you had some people around who could better advise you on the topic?
Right.
Let me put in a word on that. You know, the REINS Act, for better or for worse, is perceived as a partisan project. I don't think it's going to get through a Senate with a 60-vote cloture requirement. I think we should step back and say Congress in the 1970s was big into using legislative vetoes to keep itself in the process by saying, agencies, you go do your work, but on the back end, we're going to be able to say, nope, we didn't mean that. And eventually, the Supreme Court in the early 80s said, no, that's unconstitutional. Any formal act of Congress needs to be going through bicameralism and presentment, where the president has to sign. So as a matter of formal logic, the court's opinion is very strong, but it left Congress in a much weaker place. And Congress has tried to sort of recreate the legislative veto in various forms over the years, one of which is the Congressional Review Act that Yuval and Senator Toomey talked about earlier. It's not that good of a replacement because the president can veto it. So most of the time, the president's going to protect their own agency's actions.
Right.
So what Senator Toomey was talking about with Section 232, the kind of device he was trying to build, I see it as we need to talk more about those for particular areas. I don't think those should be seen as partisan projects. I think those can be, again, protecting Congress's institutional prerogative. Another good example, the National Emergencies Act. That's one that's gotten a fair amount of play in the COVID era. The president has a lot of scope to declare a national emergency and sort of unlock extra powers as a result. Congress can vote down those declarations of the national emergency. Oh, but the way they do it is with a joint resolution which the president can veto. So the president is just in such a structurally strong spot, and Congress has not been that creative in figuring out how to put itself on a level footing. So it has some resources, it has some choices that it can make. Justice Breyer wrote about how we could recreate the legislative veto in a constitutional way, all the way back in the mid-1980s. So the ways are there if there's a will.
Interesting. So back to you, Molly. As a student of Congress, what are you most concerned about going forward? And if somebody was trying to study, if there was another political scientist or a graduate student out there who was trying to study the impact of this decision on Congress, are there any solid objective indicators that might reflect its influence?
Yeah, so I'll start with the first part of your question, and I'll just say that my biggest concern here is that, sort of in two parts. One is that Congress may not rise to the moment. So you certainly heard Senator Toomey sort of intimate at this possibility in his remarks. But then also, even if Congress does the kinds of things that I think we have articulated that we would want to see in response to this decision, that's ultimately not sufficient to counterbalance the interest of the courts in trying to expand their own power here. And some of this is because of what I talked about earlier in terms of Congress's structural challenges in writing detailed laws, but it's also because I think the decision, and we've been mostly focused on Congress, but I do think it represents some transfer of power to the judicial branch. And I think more importantly, there are just a lot of open questions about how things will actually play out, what will replace Chevron deference. I'm not an administrative law expert. I understand there's a sort of vigorous debate among administrative law experts on what might come next. Will we end up with sort of the courts saying no a lot? Will we end up with agencies just being deterred from acting? I suspect our next panel may take up that question. We could theoretically get a more powerful legislature, but I'm sort of skeptical that that's kind of the ultimate goal here. And I think that there are, so I just think there are a lot of open questions about sort of what comes next. I think many of them result in sort of the courts making more decisions than they were making now, and that even a vigorous investment in congressional capacity doesn't really forestall that possibility. In terms of sort of how will we know what matters, I will say there's a really pretty robust literature in legal academia on sort of the question of that's tried to document the effect of Chevron, sort of when is it used. Does congressional bill writers sort of understand what Chevron and other statutory interpretation canons, what they are, how they get used? How does Chevron deference interact with things like the partisanship of the president who appointed a federal judge in terms of how we see it used? I expect that sort of as post-Chevron, post-Loper Bright deference standards continue to evolve, we'll see a similar effort to kind of tease that out empirically, and I'll be very interested to see what folks find. But I think we have again we have a pretty good blueprint from sort of studying the effects of Chevron.
Yeah, interesting. I didn't think about looking at what they had already written about the impact of Chevron, but that's a great. Yeah, and so Kevin, if you were a betting man, will Congress move off its current trajectory? Would you bet that they will move off their current trajectory?
That's not really one of your vices, I think.
I'm cautiously optimistic. I think there's a kind of deeper conversation that needs to be had, and that legislators are going to have out with one another about the question of do we want this legislative power? Do we want this authority? I mean, James Madison's probably spinning in his grave because he just presumed that people would want to, in the legislature, would want to wield such power. But there are rational reasons for an individual legislators or legislators collectively to back off. One of which is that, say you're a Republican and you feel like, hey, there's a good chance that we might win the White House. I have a policy objective A, B, and C I want achieved. Well, I could go through the grind of the legislative process Or I could just cross my fingers and hope that our guy wins, and then we can ram it through my policies through the rulemaking process. That's a kind of rational, efficient reason for just skipping it. It's also the case that there are some people in Congress who they privilege policy perfection over representative policy. They genuinely prefer experts ensconced in agencies to make decisions rather than Congress, which they look upon as a place full of people of inadequate knowledge and expertise, people who are influenced by special interests. I mean, this is why we have agencies that have been put outside the appropriations process, because there is this belief that, no, Congress is not up to this. And unless that conversation is had out and you have members kind of thinking about, well, what do we really conceive of ourselves as? What's our job here? Are we simply just enablers of the executive branch, or are we people who are actual lawmakers? That's got to be ground through.
Yeah.
But I would imagine that there are going to be victories on the margin for congressional capacity.
Yeah, which is another great lead-in. Thank you again. I can't let you go, Phil, without talking about this idea and like fleshing it out a little bit more about this new Congressional Regulation Office. It seems like an idea whose time has come.
I hope so. You know, many people probably don't know what OIRA is. Everyone who studies these subjects knows OIRA is this office called the Office of Information and Regulatory Affairs. That's a part of the Office of Management and Budget, which is itself part of the Executive Office of the President. So OIRA is on the President's team. It's also sort of known as the Regulatory Nerve Center. It's a clearinghouse of regulation. It tries to coordinate between agencies, and it does a fair amount of evaluative work when agencies have a proposal. Well, Congress ends up relying on OIRA an awful lot, and sometimes OIRA does very good work, and that's fine, and other times OIRA should be thought of as playing on the President's team. And Congress really shouldn't be in the position of having to depend on OIRA as much as it does. It should build its own in-house capacity. And so it could try to do that in any number of ways. It could try to beef up the GAO or the Congressional Budget Office itself. But Kevin and I proposed, why not build a Congressional Regulation Office that is about trying to build a cost-benefit test capacity within the institution. The idea is to do objective estimates of what new policies would do, also to do retrospective analyses of what existing policies have accomplished, and then also to help Congress more ably sort of take stock of where different regulatory areas are. Because things are so complex, Congress is never going to build itself a parallel executive branch. Mm-hmm. That's not possible just on the math. But trying to keep some neutral expertise in-house that helps it be able to wade through these complicated problems, knowing who to bring in from the outside. I think another part of the appeal of this is if you think Congress is too beholden to special interest, building its own in-house capacity is a way to make it more able to sort through things ably, even if it does have to always be listening to outsiders.
Yeah, it is an idea whose time has come. I'd like to turn it over now, and thank you, all of you, each of you, for exceptional answers and a really interesting conversation. I think there might be some questions out there, and I'm hopeful that there are. And we have people with microphones that'll come around and ask them. So if you want to raise your hand.
Hi, thank you so much. I'm an intern here at AEI, the Academic Programs team. I have a question for Mr. Wallach. I read your article, Can Congress Take the W on Chevron? And in that article, you talked about how Chevron was like a pillar for technocracy. But it seems to me that unless Congress can step up, and even if Congress can step up, it might be very difficult, given how difficult these provisions are, how complex these provisions are, then it will be up to judges or the judiciary to fill the role that these agencies formerly took. And so it'd be, in a sense, some technocrats replacing other technocrats. And I wondered whether that vision is wrong, and also whether some degree of technocracy is necessary or unavoidable.
Thanks for the question. I think, listen, another thing Loper Bright does not say is that whenever agencies interpret a statute, they must be wrong. It says that judges ought to give due respect to what the agency has to say when it interprets the law, and they may very well get it right. But it says that they don't get the presumption of they don't get the benefit of the doubt where, as long as they're being reasonable, they win. No, it's not that much of a lean anymore. So I think, there are those people who would say, listen, all of this is overblown. Actually, none of this matters very much, because in the end, the judges are just going to listen to the agencies anyway, because they don't really have any other choice. Because judges are not technocrats. Judges are generalists who study how to do law. But when it comes to all these technical areas, they don't know a thing, and they're just going to listen to the agencies anyway. That's a position that some people have, that this is all being totally blown out of proportion, and things are not really going to change much at all. I don't think that's right. I hope it's not right. I think Senator Toomey put it very well, that too often agencies are judging themselves, and there are hard questions, and they're putting their thumb on the scale to give themselves new powers, and in evaluating whether that was appropriate, courts are asked to just say, are you being sort of reasonable? Yes, well, okay, go on with what you're doing then. That's what's supposed to be put an end to with Loper Bright. So I think that's all to the good. I don't think there's a constituency for saying all decisions need to be made by our democratically elected officials. I don't think anybody involved in government really thinks that's a live possibility or is something that they're deeply invested in. I think you have to be very into abstract theorizing for that to be appealing. I think so. Agencies are going to go on making decisions. They're going to have a lot of responsibilities. Courts are still going to accord them lots of respect. But I think the way to think of it is just the thumb is less on the scale on their side now.
Anyone else? No?
Thank you. My name is Patrick. I currently intern for a member of Congress in the House of Representatives. So my question is, with this ruling, should Congress go back to the drawing board on the fiscal year 25 Legislative Branch Appropriations Act, which recently failed in the House last week, and readjust the amount of funds they're appropriating to each member office or committee office, legislative council, and other congressional offices?
Molly or Kevin, do you want to take it?
Budget process.
I mean, I suspect that Kevin and Phil would agree with me that there are reasons why there were reasons before this decision why it would have been great for Congress to spend more money on itself. It is probably the case that given this, the sort of respective division of resources maybe should look a little different. But again, this question of increasing Congress's capacity in the current fiscal year legislative branch appropriations bill, in future fiscal years legislative appropriations branch bills, I think we should think about that as sort of necessary for helping Congress do its work in this new era, but probably not sufficient. I don't think that's enough to sort of address all of the challenges that for the institution that the three of us have highlighted.
Okay, I'm going to read one of the questions online, and then I'll turn to you. The question is, in the aftermath of Chevron deference, is Congress's power of the purse, its writing of appropriations laws, relevant to the court's interpretation of other laws? For example, should Congress's appropriations for the EPA affect the court's interpretation of the Clean Air Act? It's a hard one.
It is. I mean, the fundamental tension here is that when an agency does this move of taking an old statute and making it do something new, like the EPA has done over the last couple of decades for climate change, all of which is based on this old statute that was written to control local air pollution problems. Congress goes on funding the agency. Republicans on the Hill all the while have pretty much said, we think this is all illegitimate, and have supported litigation attempts to knock it out. President Obama's big signature rule for existing power plants was knocked out. Litigation is ongoing. But Congress sort of mostly, again, plays the bystander, has rooting interests, says who it wants to win, doesn't provide any resolution through its ongoing appropriations or authorizations, some of which are just neglected altogether. So it just lets itself be cut out of the loop and yells about what's going on.
Yeah.
That's the dynamic we've got. Unfortunately, it's all too easy for that dynamic to continue. But again, there's just no substitute for actually legislating if Congress wants to be a serious player.
Yeah. Kevin, do you want to add on?
I just want to add, it's a really intriguing question, and it prompts another question, which is, will there be some sort of legislative response that aims to influence possible court decisions, such as, if you're the sponsor of legislation that's about to be voted on, to introduce a statement about this is the purpose of this provision, that sort of thing. Will committees, in the course of grinding out and reporting out bills, will they try to signal this is what we mean by the law, but not that thing over there, in anticipation of laying the groundwork that if there's ever a challenge, then the courts are going to have to say, oh, well, this was said here, and then where funding and how a court would look upon that as approval, tacit approval, whatever. Very intriguing question.
Yeah.
And then I think that sort of leads to a follow-up question, which is, as you were sort of getting to, which is, what will courts do with that information? So we know at this point that different judges have different ways of viewing the products of Congress's internal deliberations in making their decisions. I suspect that in the aftermath of Loper Bright, that will become increasingly important. The idea of how does a given federal judge or a group of federal judges reason through and view a committee report versus what was said in the committee hearing versus what was said on the floor, and what inferences do they draw from that? What weight do they give that information? Just as we're having this conversation about what weight is appropriate for judges to give agency interpretations, whether it's something that looks mostly like what they were doing under Chevron, whether it's no deference, whether it's something in the middle, what that in the middle is, I don't know.
So we'll have one more question, and then we're going to take a 5-minute break and come back, and we'll discuss Loper's impact on agencies. So, yeah.
Yeah, John Vecchione, I'm counsel of record in Relentless. And sitting next to me is counsel for Loper Bright. What do you, as academics, people who've studied this, what do you make of the assertion that Congress was relying on Chevron consciously all these years? That they were thinking about it when they drafted legislation before this happened?
So I think we have some empirical evidence that says that sometimes people in Congress were thinking about Chevron, sometimes they weren't. I'm not familiar enough with all of the work to be able to talk about all of those patterns, but I do think that there is some sense that, and particularly in the case of Chevron and being perhaps the most famous, doesn't feel like the right word, but perhaps the best known of these statutory interpretation canons, that it was and can be on people's minds. I do think, though, that that question leads to and fits in well with this bigger question of, well, then what comes next? And do we have folks who are doing this work who are thinking about the possible ways the work is going to be interpreted?
I also thought the chief just had by far the better of it on that. What does it mean to rely on Chevron exactly when, in fact, there were lots of cases when Chevron just doesn't get applied? The Chevron step 0 is kind of hard to know what exactly is going on there all the time. So I think, we traded some kinds of uncertainty for other kinds of uncertainty by changing the regime just now, right? You know, Chevron preserves a great deal of policy uncertainty because it builds so much flexibility for the executive branch to just fiddle with policies at their desire and be able to justify those changes. You know, now we're going to have a different kind of uncertainty. I think it's fair to say we all have a lot of circuit splits. I don't know if the Supreme Court will clean them all up, and so that might be its own source of uncertainty for the future. But no, I think we'll do okay.
I'd like to thank all of you for coming to this panel, and if you'd like to come back for the next one, just a 5-minute break and we'll be back. Thank you. Congress was likely not the only institution abuzz in the aftermath of the Loper Bright decision. On its face, it seems like a blow to the role of expertise within the agencies. The proverbial thumb on the scale that may have favored government and supported expansive regulatory programs is no longer there. How might executive agencies respond? And we're fortunate today to have three exceptional experts on this topic. The first to my right is Rachel Augustine Potter. She's an associate professor of politics at the University of Virginia, a senior fellow at the Miller Center, also at the University of Virginia, and an award-winning author of the book, Bending the Rules, Procedural Politicking in the Bureaucracy, published by the University of Chicago. She has testified before Congress and worked at OMB, GAO, and the German Federal Ministry of the Interior. Her most recent article in Duke Law Journal, Regulatory Body Shops, explores the role of outside contractors in rulemaking. Jonathan Adler is the inaugural Johann Verhey Memorial Professor of Law and Director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law. He has written extensively, the author of numerous articles and 8 books, 2 of which were published by AEI and Brookings. He is no stranger to Congress, having testified there a dozen times, and teaches courses on environmental, administrative, and constitutional law. Tony Mills is a senior fellow and director of the Center for Technology, Science, and Energy here at the American Enterprise Institute, where he focuses on the government's role in science and innovation, as well as the relationship between expertise and democratic governance. He is also a senior fellow at Pepperdine School of Public Policy. His writings have appeared in the New York Times, the Wall Street Journal, National Affairs, Issues in Science and Technology, the New Atlantis, and various peer-reviewed journals. He is currently completing a book on the crisis of the federal scientific establishment. So welcome to each of you. And I think I'm going to start with an opening question to Jonathan, our token lawyer on the panel, I might add. Can you set the stage by giving us some historic context? How did we get here? Tell us what's been happening since Chevron was decided in 1984, and whether you could see this train coming. When we spoke the other day, you mentioned something about agencies pouring new wine out of old bottles. Explain.
Sure. So I think it's worth, in terms of thinking about the effect of Chevron is going to be on agencies, it's worth thinking about how we got to this thing called Chevron. Because when the case of Chevron versus Natural Resources Defense Council was decided in 1984, no one thought much of it. It wasn't a case that was ever clearly destined to the Supreme Court. It wasn't seen as particularly cert-worthy at the time, although the court did grant it. The court did not think it was doing anything new. We know from the papers of the justices that Justice Stevens thought the court was applying the same approach to judicial review of agency action as it had been applying for 40 years. And that is looking at the full range of materials and sources of statutory interpretation and giving due weight or respect to the views of the agency. And the issue before the court, whether or not the word source in the Clean Air Act for certain stationary source provisions should refer to an individual discrete smokestack or point at which emissions are emitted from, or a larger building or facility as a whole, wasn't a question of technical expertise, wasn't a question of scientific analysis. It was a policy question. The Reagan administration wanted to define source more broadly because it would make it easier to comply with the Clean Air Act. It would allow for greater flexibility in agency compliance. And the court upheld that because in its view, when it looked at all the relevant sources of statutory interpretation, it didn't think that Congress had answered the question, didn't think Congress had focused on it. And since this was, at the end of the day, a policy question, it thought that it was the sort of policy judgment that Congress entrusted to an agency, and had not enshrined in the statute. All anyone thought that had happened in that case was this particular question about the Clean Air Act had been decided. It literally wasn't till years later when both some judges on the DC Circuit and officials in the Reagan and then Bush administrations decided that this one paragraph in the opinion, the paragraph that all of my students in administrative law and leg-reg and those sorts of classes pretty much have to memorize, or had to memorize, not anymore, about these two steps, was, because of the way it was framed, because of the language used, started to look like a test. And in particular, the Reagan and Bush administrations used that paragraph to push back against legal challenges, typically by interest groups, to agency interpretations that were designed to make regulatory programs more flexible and less stringent than they were otherwise. And this idea of there being a doctrine was something that grew up over time after the fact as a way of the executive branch pushing back against outside litigation and, to be fair, a DC circuit that at the time was, had accepted what some saw as Congress's invitation to read various regulatory statutes with broad purposivist language in very broad terms and aspirational terms. And then over time, this became, as it was cited repeatedly in particularly in DC Circuit opinions and then Supreme Court opinions, a test that was applied, and one that gave agencies an extra source of authority. As a practical matter, it was also something at least some judges liked, because a lot of times, as was noted, what Kevin noted on the prior panel, the subject matter of a lot of these cases is mind-numbing, particularly for generalist judges who might see one Clean Air Act case a year if they're lucky, 2 NLRB cases, 1 FDIC case. And so they have to learn all this stuff for each case. And if it gets really complicated, it's pretty easy to say, well, what the agency's doing isn't so crazy, we'll just go with them. So Chevron, ended up being more widely adopted and embraced in courts because it was easier for judges in terms of enabling them to do their jobs. Agencies come in, they give us a good explanation, a good rationale, we'll go with them. We really don't want to spend the next 4 days parsing this language that may or may not have been written all that clearly. The problem is, and this relates to seeing the train coming, is that the way certainly the Supreme Court viewed this being adopted by various agencies is it went from letting agencies share their knowledge about how a complex statute is supposed to work in practice, perhaps even their knowledge about how the statute was drafted, because we certainly know there are lots of statutes that agencies cooperate in the drafting of, to one of almost judicial abdication. So Justice Kennedy, in one of his last opinions as a justice on the court, in a concurring opinion in a case called Pereira in 2018, laments how this had gone from giving respect to agencies and deference in agencies to just abdication. Just, a trump card that the agencies get to play. And that in particular, this was happening in cases where the question wasn't something discrete and narrow, like what the meaning of source is, but questions more like what we see in Loper Bright and Relentless about, does the agency have this power in the first place? And that being is a particularly different sort of question. It's a sort of question that agency expertise plays less of a role, and one that is really about this initial allocation of powers. Did Congress, in fact, give this power to the agency? And that being a limit that courts are supposed to enforce. And so I've argued that between that opinion from Justice Kennedy, Chief Justice Roberts' dissent in a case called City of Arlington versus FCC, that we see this increasing concern about abdication, and magnified by this is the last point, and I'll shut up, magnified by the practice that we've been seeing increasingly in the 21st century, that among others, Elena Kagan, as an academic, helped document, where a lot of policymaking is being centralized in the White House and the executive branch. And in a time in which Congress is not reauthorizing statutes on a regular basis, the practice is not, gosh, there's this problem, let's get Congress to do something about it and then we can implement it. It's, gosh, there's this problem, here's what we want to do. Can we find an excuse, or can we find an authority? Is there somewhere in the US code there's language that allows us to do this? And so if you look at the various major questions cases, especially in the oral arguments of those cases, you see the justices really concerned about an administration saying, here's an all-of-government policy we're adopting for COVID, an all-of-government approach we're adopting for climate change. Basically, we've set the policy goals apart from Congress, and now we're just trying to find tools or weapons that were previously given to us for other purposes. And I think if you go, and we'll get into this perhaps, if you go through Chief Justice Roberts' opinion in Loper Bright, I think you see that concern throughout the opinion, as we have in the major questions decisions, about agencies taking power that's not rightfully theirs, and that's really, that's the train that was coming, and that's really what's more significant about the opinion than Justice Gorsuch's tombstone to Chevron, which is what gets the headlines. But what's really about is there's a certain type of delegation of power that courts have to retake authority of disciplining. And that was a concern that, again, goes back at least 6-7 years on the Supreme Court.
So the answer is yes, you did see the train coming, though.
I hope so.
Yeah. Yeah. Okay, great. Thank you. Tony, Jonathan mentioned expertise, and I wanted to ask you a question about that. It strikes me that the Loper Bright decision's impact might vary across policy areas. Economic, environmental, financial, et cetera, and it might vary across agencies as well. So might this decision affect the balance of power across the three branches? And will there be a period of, oh, I'm sorry, I missed that. So economic, environmental, financial, some agencies like EPA seem particularly under the spotlight. Can you talk about why the impact of this decision will likely be variable?
Sure. Yeah, I think your question points to this larger one about the role of expertise, which you also mentioned in your opening remarks. I think maybe to start, and I'm sure Jonathan and Rachel have a lot to say about this as well. And to think about the impacts, we have to take stock of what the decision does and doesn't do. And this was said on the first panel, but I think it's worth echoing here that the court is not saying in Loper Bright that Congress can't, that the EPA or the FDA doesn't have regulatory power, doesn't have expertise that's relevant to that. It's focused in on those cases, as everyone here knows, where the statutes are deemed ambiguous or where Congress is silent on a given issue. Now that's a lot of instances, but it's not everything. And so I think as a starting point for thinking about the impact that this decision will have on agencies, we would have to look at which policy and regulatory decisions agencies are making appeal to ambiguous statutes in the way that Jonathan was describing, or in less maybe egregious ways where it's just sort of part of the rationale for an agency action. And you'd really have to look case by case. But I think there's a larger question here around the expertise in the agencies that's worth addressing maybe prior to getting into those details. Because I think a lot of the framing around this case and around the debate over Chevron is in terms of pro-expertise or anti-expertise, pro-regulation or anti-regulation. And the first thing to notice, again, echoing what Jonathan said, is that Chevron deference is not itself pro or anti-regulation. And in fact, for much of its history, it was used by Republican administrations in order to reduce the regulatory burden. And so there's an irony there, but there's also an important lesson, which is that in principle, we're not talking about something that's intrinsically pro or anti. And that's, I think, maybe we can come back to this. It's worth thinking about, particularly in the context of the broader politics that we're in, political moment that we're in now, where Republicans and Democrats, for different reasons, may want to restrict executive power. And there are interesting questions about the impact that Loper could have on the agendas of both parties, actually. But on the issue of expertise, I think the other thing that's important to keep in mind is that expertise is only one of the rationales for Chevron. It's not the only one. It's an important one. But there are lots of instances where statutory ambiguities don't turn on scientific or technical expertise, as Jonathan was alluding to. But it's nevertheless an important part of why of the defense of Chevron deference, and it's an important part of the larger context, right? So we're in a moment where we have the kind of crisis of trust and expertise, and I think the politics around administrative law and Chevron in particular are seen, rightly, to some degree, in that larger context. But if you look at what the court says in the majority opinion, it's interesting. It's quite clear that it's not attacking expertise. The way I read it is first as reminding us that expertise is not one thing. That agencies do have subject matter domain expertise. The EPA has tons of experts on toxicity and all other sorts of aspects of environmental and health sciences. Agencies also have policy expertise and practical administrative expertise. But when you're considering ambiguous statutes, you also need to think about legal expertise. And what the court is very clear, what Chief Justice Roberts is very clear about, is that legal expertise is quite important when it comes to interpreting statutes. And that's the purview of the court, legal expertise. And so you can almost think about the decision as a kind of rivalry between different forms of expertise. And the way I read the opinion of the court is to say, when it comes to questions where what's at issue is the scope of the agency's power, which is, as Jonathan mentioned in a few of his examples, what's often at stake when it comes to these ambiguous statutes. The court is saying agencies don't have the competence to decide whether they have the competence to decide that question. It's a sort of meta claim, right? That their competence runs out when it comes to determining the scope of their own expertise, precisely because questions of law are at stake. And this is, I think, a kind of practical argument that courts just in fact have this expertise. Of course, agencies have legal experts too. I think ultimately the strength of that argument is that that's the role of the court in the constitutional system, and based on the court's understanding of the Administrative Procedure Act, the role of the court is to interpret law. And so there are many instances in which, when we're dealing with ambiguous statutes, the expertise that comes from technical domains or from policy or from law are all kind of jumbled together in ways that are difficult to separate out. And Justice Kagan in her dissent really focuses on those examples. And the argument is, well, maybe there are these differences between expertise, but in practice, we can't just say you do this and you do that. It's really kind of a mess.
Right.
And what the court is saying is that's all true. But that's not a reason for the court to obviate its responsibility to use its legal expertise in these particular questions. And so that's sort of a framework that I would use for thinking about how it would then impact different agencies.
No, that's really helpful. And Rachel, I invite you to chime in on either of those questions, but I also wanted to ask you to think about the agency's response relative to other major political institutions, and might this Loper Bright decision affect the balance of power across the three branches? Will there be a period of redefining agency power, and what might that look like?
Yeah, so I think we are at a point where we're actively rethinking agency power. And how are agencies responding to this? Well, they're not responding in a vacuum at all, right? They are responding to the broader political environment. So I want to talk about that for a moment. So when I say this, what I mean is Loper Bright is not necessarily the headline. So in the last term, the courts issued several cases involving agencies. So there's a case called Corner Post that was just decided, where the statute of limitations on agency regulations was previously 6 years from the date of finalization. Now it's 6 years from the time the plaintiff suffered injury. So basically, there's no statute of limitations to sue agency about regulations anymore. There's another case, Ohio versus EPA. This is what one law scholar described as fly-specking the notice and comment record, where the EPA was overturned by the court for not adequately responding to each and every comment it received. There's another case, SEC versus Jakarzi. This case involves civil penalties at the SEC. And what the court ruled was that the SEC can't adjudicate those claims necessarily all on its own, that they must work through the judicial system to adjudicate those. And I'm going to bring in a case not from this term, but that many of you have heard of, West Virginia versus EPA, which is the major question doctrine case from 2 years ago. So I mention all of these cases because they all have something in common, which is they all ruled against agency power, right? They all say we're limiting agency power. And I'm going to just quickly go through how these cases were decided, right? So we have Loper Bright, which is decided on a 6-2 basis because Justice Jackson had to recuse herself, but on Relentless, it's a 6-3. Corner Post, 6-3. Ohio versus EPA, 5-4. We got Justice Coney Barrett sided with the liberals. SEC versus Jakarzi, 6-3. West Virginia versus EPA, 6-3. Okay, so stepping back from that, right? I'm not a lawyer. Many people working at agencies are not lawyers either, but they're going to have to respond to this new environment, right? And so one way to look at this is to say, wow, there is a conservative majority in place, and they are working on a project to constrain agency power. This is something that this is how this court views agency power. If we take a step back further, right, we're thinking about the political environment, and we say, well, what is Congress doing in response to this, right? Well, we heard from the last panel and from Senator Toomey that there's not a lot of confidence that Congress is going to take up the mantle, right, and on the legislative capacity front and take up more the project of more detailed statutes. Instead, what we heard is about different bills that have been introduced that would constrain agency authority. Okay, so we're seeing a theme, right? There's not been a coordinated Democratic response on the Hill, as far as I'm aware. If we take a step further back and we think looking forward to this election in November, right? We have Donald Trump refers to the administrative state as the deep state, right? This is a deep skepticism of the authority exercised in the bureaucracy. He has promised to reintroduce Schedule F, which is a policy that would convert up to 50,000 career civil servants to a political appointee-like status. So these are, right, policies that are working in different ways to constrain agency power. Right, that would maybe look different under a potential Biden second term. So we don't know how that's going to play out. But this is the reality that agencies are encountering right now. So what does this mean? Well, I think what we have is a lot of different inroads to curb agencies if they overstep, whatever that means in the context that they operate in. So how can they respond? Well, there's still, as we've made clear, there's still delegation, there's still rulemaking. And there's still probably some amount of deference, but we can expect agencies to move really slowly, right? They got to figure this thing out, and it's going to take a while, and they're going to have a lot more lawyers involved. So I would also expect the workforce to change a little bit, right? Maybe agencies start hiring even more lawyers. I will say that between 1973 and 2023, the number of lawyers in the federal government quadrupled. So this has been already a trend. We might also see a move towards other actions. So regulation and rulemaking are the focus, but we might see agencies taking up more enforcement actions or adjudication. And we might also see more exits from agencies as career civil servants look at this landscape and say, wow, I thought I was coming into this institution, which for a long time has looked a certain way and might be really different going forward. So my expertise might, to the extent that we can talk about what expertise means, but might not be the same as what I thought it was when I took this job. So there's a lot of different implications, and I think we're going to spend the next couple of months and years figuring out what agencies actually do.
Yeah, interesting. I wanted to ask you, but generally speaking, does it shift the balance of power away from the executive to some extent to the courts? How would you talk about that dynamic?
So for the last couple of decades, right, we've had a steady aggrandizement of executive power, where the executive branch has steadily accrued powers. What we see here is the court saying, wait, we're going to decide a lot more of that. So they're taking that power for themselves. And so what is Congress going to do in this project? I think that's right. And I have to say, like, the response the immediate response to not say, well, we're going to increase capacity. It's a longer term conversation, but this is, I don't think, a surprise for anyone on the Hill, right? That this conversation about what does delegation look like. The response that these bills are trying to curb agencies rather than focus on the institution itself is interesting, right? So I don't know that we know what's going to happen with the balance of power. It's definitely shifting, right? This is a power grab by the judiciary, and so I think the ball is in probably Congress's court.
Yeah, interesting. Jonathan, I'm curious about how this decision will affect the relationship between senior White House staff and agencies. In the past, senior White House staff have been able to work closely with key agencies to influence regulatory policy. Might this change since it will be more difficult for agencies to change their interpretation of a statute?
Well, I think it will affect the relationship between the White House and agencies kind of in two ways. One is this decision will make it more difficult for agencies to change their interpretations of statutes and the way they implement and enforce statutes. The court didn't expressly overturn a related case called Brand X, but the obituary is basically written. This was a decision, Brand X, where the court had said that even if a statute had been previously interpreted by a court, that under Chevron and under the logic of Chevron, if the language is ambiguous and the agency changes its interpretation of the statute at a later date, the agency wins, even if there had been a prior court interpretation. That particular holding was something that had that several of the justices have been extremely critical of, in part for the rule of law implications. That there could be a judicial decision saying that an immigration statute, an environmental statute, whatever, should be interpreted and applied a particular way, and that an agency just gets to change its mind about what the statute means. And the court further in the Loper Bright and Relentless opinion says that agency interpretations about what statutes mean get more weight or more respect if they're contemporaneous with the statute's adoption and they're longstanding. So that there are reliance interests. If an agency has been consistently saying for 20 years, this is what the statute means, well, the regulated community, Congress, everyone else gets to kind of, well, rely on that, especially if that was an interpretation given right when the statute was enacted, again, acknowledging that the agency may well have been involved in drafting the statute. But that when an agency comes along in, say, 2016 and says, oh, here's the Clean Air Act language adopted in 1990, it's never been used this way before, but we now think it means something else, that we're going to be more skeptical of that. Mm-hmm. That's the second way it affects the ability of the White House to change policy, because as I noted earlier, one of the things we increasingly see is a White House comes in, it has an agenda, it has a policy agenda that cuts across agency authorities, and it wants to implement that. Adopt an executive order telling all agencies to use their authorities to advance X, right? Reduce greenhouse gas emissions, address COVID, what have you. And they're basically saying to the agencies, forget what Congress told you to do. Forget what the various statutes that delegated authority to you were focused on and the instructions they were given. We're giving you new instructions. So Congress may have given you wrenches to use as wrenches, but as people in my family might say, if I'm up in my daughter's room, which is on the top floor of our house, and I have a wrench, and I suddenly realize what I really want is a hammer, rather than go all the way back down to the basement to get my hammer, I might just turn the wrench on an angle and hope that I don't slip. And because it's a hard metal thing, and it can drive a nail at least into something soft. Hopefully not my finger. And that practice is something that I think this opinion, especially in context with the other opinions raised, that makes it harder for the White House to do. Mm-hmm. Because the court's message is, if Congress gave you a wrench, use it as a wrench. And if what you really want is a hammer, go back to Congress and ask for a hammer, mm-hmm. even if that takes time and effort and whatever else. And I think that does affect the ability of the White House to set broad kind of executive branch-wide policy in areas that Congress has not expressly spoken to.
Interesting. Interesting. You might get called on in the future for advice about how they can sort of work around that. Is there a third way? So I also want to pose a similar question that I did to the last panel, which is to invoke the Katzmann initiative again, because I'm very fond of it. It focuses on interbranch relations and how the Loper Bright decision might affect agency relations with Congress and the courts. So Tony, then Rachel, how might this decision impact interbranch relations?
Well, I think both Rachel and Jonathan have already spoken to this to some degree. I think the most obvious way it will impact the relations is in terms of how it shifts the power centers. And it's, I think, fair to say that Loper Bright restricts the scope of agency power and it tilts it toward the judiciary. Mm-hmm. I do think it's important to, and I don't want to trivialize that, but I do think the context is important, not only the history that we talked about earlier. Another thing that's important is that Chief Justice Roberts is explicit in his opinion that when it comes to matters of fact, which is typically where technical expertise is most pertinent in an agency, the traditional deference that the court gives to the agencies is untouched. That's not what Loper is about. It's about the ambiguous statutes. So it's not like all the deference is going away or anything like that. But nevertheless, I think it's important. And the way I see what the court is doing here is essentially trying to articulate what its appropriate role is and the appropriate role of the agencies, and the appropriate role of the agencies vis-a-vis Congress. And I think it's clear that the concern, which Jonathan was describing well, is not just that agencies had accrued too much power, but that you had these perverse outcomes where, every 4 or 8 years, the agency priorities just seesaw back and forth. And one of the reasons for that is that agencies can look to these statutes, sometimes very old statutes, and just use them as rationalization for a policy decision. And so if you kind of step back and think about the broader politics of the institutions of the federal government, it makes the agencies and it makes the presidency really, really important, because whoever is elected gets to set the agenda in a really profound way for these agencies which have accrued more power. And then that can just change. And that's unpredictable. There are all sorts of reasons why that's not ideal. There are also constitutional reasons, separations of power reasons, why you might think Congress should be the place where those sorts of contested questions are being hashed out. And the court is clearly worried about that. And so the remedy is to tilt power back to the judiciary by articulating more clearly the role of the court in statutory interpretation. One perverse outcome of that could be that the court becomes too powerful, which would be kind of an ironic outcome, because the original rationale for Chevron, at least one of them, was a worry about the courts becoming too powerful, and that's why a lot of conservatives at the time supported it. Again, the ironies just proliferate. So I think that's a real concern. I think that's a possibility that the defenders of Chevron are right to point out, that Justice Kagan is right to emphasize that in her dissent. We don't really know exactly how that will play out, but it's worth thinking about. What I do think, here I'm just echoing a lot of what was said on the first panel, but Loper doesn't say anything about giving power back to Congress, but it creates an opening for that, for sure. And there is where I'm hopeful that we will see an additional shift of power between the three branches of government back toward Congress, which would be one way of addressing some of the uncertainties and downsides of what I think is the correct decision that the court made. One kind of specific thing to say there, which I think Phil mentioned in the first panel, but I just want to reiterate, again, this is something that the majority opinion is explicit about. The court's not saying that Congress can't give agencies this meta expertise I was talking about, meta competence. It just says Congress has to be explicit about it. And Congress does, in fact, in many instances, do that. It says the agency is going to, here's the statute, in the statutory language, it's not only saying to do this thing broadly speaking, but also that the agency has this kind of authority over this domain. And one relatively straightforward way Congress could respond to Loper Bright would be to do more of that. That's a relatively light lift. I don't want to be...
They like life.
That's my point. I don't want to be naive about how challenging even that might be in practice, but it's a relatively light lift, considering the broader challenges that we've been talking about with revitalizing Congress.
And Rachel, if I can just steer the question a slightly different direction, I'm just thinking about the general contentiousness between Congress and the executive. And the general contentiousness of independent judges being annoyed by Congress, passing laws that are affecting the judiciary and such like that. Does it raise that temperature, do you think? That overall kind of atmospheric temperature?
Well, the way I'm thinking about this, and this goes back to a comment that Phil made on the last panel as well.
Everything goes back to Phil, right?
Yeah, it goes back to Phil again and again. But there's not a congressional response to a lot of these things. There's an institutional response. There's a partisan response. So some people have said this court, and Loper Bright doesn't fit well in this, but they've said this court is really interested in a unitary executive, building a unitary executive, which is the idea that the president should fully control the administrative state. Now, Loper Bright kind of complicates that, as Jonathan is saying. President won't be able to control everything agencies do, but Congress doesn't have, so the conservatives support a unitary executive theory, liberals don't. Right? But what is Congress's position? They're not unified in sort of saying this is what our institution says about this. And so it's hard to know, right? What is the institutional response if people don't feel like they're institutionalists, right? And they're not part of the same team. And so I don't know that there is a coordinated response in that sense. But I do think people, we're at a point of extreme hyperpolarization. right? I think everyone knows that. Political scientists have been documenting that again and again and again. So yeah, the temperature's raised already, and this probably doesn't make things all that much easier.
Yeah. Yeah, and Jonathan, if you had to predict where we might be a year or two from now, how might you characterize the role of expertise within agencies, recognizing that it varies and will vary across agencies? And since you're a professor, I think you can probably give us a hypothetical. So it'd be great if you could include an example.
Well, I mean, so I think one of the things that Chevron encouraged was, and I want to try and say this in a way that doesn't get too deep into the legal weeds, because there are two questions that often overlap, right? One was under Chevron, if a statute was ambiguous, what is the range of permissible or reasonable interpretations the agency could adopt of that language? And there's a separate way of judicial review agency action that we generally refer to as arbitrary and capricious review, which is the reasonableness of the policy choice the agency engaged in. And as Chevron itself highlighted, the facts of Chevron that I recounted before, how are we going to interpret the word source? Not because anyone has a belief about what the better semantic meaning of the word source is, but because interpreting it one way gives you one policy outcome and interpreting it the other way gives you another one, is that we see that these two inquiries overlap, or at least potentially overlap in lots of statutory frameworks. And so in judicial review of agency action, there was often a lot of tactical choices made, both by agencies and by litigants, about how do we characterize what it is we are challenging or defending. Do we want to be defending it in Chevron space? Do we want to be defending it in arbitrary and capricious space by characterizing this as an interpretation of ambiguous text or a reasonable or unreasonable agency interpretation? I think this opinion pushes to try and reduce that overlap. You can't do it, if you're doing the Venn diagram, you can't completely disentangle these two inquiries, but you can try and separate them and push them apart. And note that conceptually, we want to think about the legal question. What does the statute mean? What authority was given to the agency? As distinct from how does the agency's expertise inform the exercise of the authority that was given? And so there will be cases, Loper Bright and Relentless, the facts of those cases I think illustrate that we can see as pretty much purely the legal question, right? Because the issue there is who pays for the monitors on the boat. And that's not a question of expertise, right? Everyone knows if the agency has limited resources, it would prefer not to use its limited resources to pay for the inspectors and have the boats pay for the inspectors. And we know the boats don't want to pay for the inspectors, and that's a policy choice. And it's informed by various other constraints, but there's no question of expertise, right? Everyone knows what the implications are of putting that burden on one side or the other. Fairly pure legal question. Justice Kagan's opinion has all these examples, like how do you define a distinct population segment of a type of squirrel? Because you have two populations of squirrels, and you want to know what degree of interbreeding do we no longer consider them to be distinct populations, which for the Endangered Species Act matters, because Congress has defined species to not merely include species, but also subspecies and distinct populations. That latter example, if the agency has the authority to list and define when one of these things qualifies as an endangered species, we can see that as more of a technical expertise question, right? There are biological implications in terms of the sustainability of a species of animal depending upon the degree. I mean, you can flesh all that out and realize there are technical questions there that aren't quite really questions about statutory interpretation. And so I think there will be a lot more attention paid to what it is that is being done. Is it a question of law? Is this question of expertise? And try and separate them. Now it's going to be messy, and there will be some stumbling. But I think over the next couple of years, we're going to see both courts and agencies trying to recognize how those sorts of questions can be at least pushed apart a little more than they have been under Chevron for the last few decades.
Yeah. So I'm sorry to report that I advantaged you in the number of questions, but it's already time for a Q&A. So, and I don't want to shortchange our audience who's been so loyal and been here for 3 hours almost. So are the microphone people ready? In the back, yeah. There. Thank you.
Thank you very much for speaking with us today. I just wanted to ask about if you could comment on how regional variation between interpretation of legislation and statutes and how different legal canons might be used, how that might vary between different circuit courts, and how you see that changing and being affected and interacting with the Loper Bright and Relentless decision.
Rachel or Tony, do you want to take that?
I'm happy to say something, but I think Jonathan's probably
Our
the one
lawyer.
to
Our
fill in the
resident
gaps
lawyer.
here. Deference to Jonathan. I get what I would say. I think it's likely that, so we were talking before about, I think the Chevron status quo had downsides. The court ultimately decided that the downsides were worse than the upsides. The new post-Chevron world is going to have upsides and downsides too. And I think one of the downsides will be we're going to get lots of litigation around the issues that are raised by the Loper decision, which could have different practical implications. And the courts are going to disagree about statutory interpretation, which they already do, but that will become the locus for a lot of the disagreements going forward. And I'm not a lawyer, so I'm not going to say more about precisely how that will play out. But I think it's fair to expect that one of the effects is going to be lots of disagreement among judges and courts about, what is an appropriate interpretation, just given the fact that that authority has now been sort of explicitly reclaimed by the court. But maybe others disagree or can say more about it.
There is some reason to believe that in some evidence that Chevron did facilitate greater uniformity of federal law. Particularly insofar as it gave courts a reason to defer to agencies. But I think that's a bit overstated, and I don't think that's something for us to worry about. We have a lot of complex federal statutes, including those that are administered by agencies that are applied and interpreted in courts all the time in cases when the agency is either not a party or there's not an applicable agency interpretation. And we sometimes get circuit splits on that, and they get resolved in the usual course by ultimately going up to the Supreme Court. And whether that's happening with ERISA or the Clean Air Act, I'm not really sure. A lot hangs on that. Reasonable people sometimes disagree upon the interpretation of complicated legal instruments or complex statutes. I also don't think that the scenario in which an agency action or an agency program is legal in one part of the country and not in the other is, again, something to be afraid of. That happens typically temporarily. It used to happen a lot more in the late 20th century than it does now. There is a whole doctrine and set of agency practices about when to engage in what was referred to as agency non-acquiescence and when not to. Congress has a lot to say about that because Congress makes choices about jurisdictional and venue provisions, basically where you get to challenge agencies. So there's some agencies like the EPA under the Clean Air Act where all regulations of national application must be challenged in the DC Circuit. So there's never a circuit split because that's the only place you go. There are other agencies where it's a blend. So National Labor Relations Board, you can either sue in the DC Circuit or in the regional circuit. Some statutes where you only sue in the regional courts. Congress makes those choices, and doing so knowing that one of the trade-offs there is the possibility of circuit splits. Last thing I'll say is there's something else out there that affects uniformity, which is the practice of universal vacator, aka nationwide injunctions under the Administrative Procedure Act, which pushes against the law being different in different places. Now, this is a whole separate panel, but I'm on Team Prelagar. I don't believe universal vacator is provided for under the Administrative Procedure Act. I don't think district court in pick your district should be able to prevent enforcement of an agency rule nationwide absent Congress having expressly given a district court that authority. But that is the norm now, and that makes regional variation much less likely because a judge in Texas or Seattle or New York or whatever can resolve that question for the nation. So I'm less worried about the lack of uniformity than some people are.
Kind of curious for what the timeline for seeing the impacts of the decision is. So is it something that in a year or 2 years or 5 years or 10 years, we're going to look back and say, oh, these predictions were kind of right, or oh, this was unexpected? Like, when will we have a better sense what the real impact of this is.
Rachel?
I mean, what we're going to see probably, right, is a lot more litigation on. So this is an opportunity. I'm sure lots of industry and interest groups see this as an opportunity. And we know that litigation takes a long time and rules take a long time. So one of the cases I mentioned, Corner Post, really opened up all existing regulation as being available to be litigated now. So, but to get to these places where we're getting to a Loper Bright decision, we've already gotten standing and gotten through all the things and really gotten to a place where we're deciding based on these grounds. So it's going to be a long time. I don't know if anybody has a specific year, 5 years. I don't know. I don't have a specific number in my head, but I'm not like counting the days.
I give two cautions, right? One, and we've seen this in the decisions that already cite Loper Bright. If you look at, there have been a handful in the last few weeks. You look at those cases, and it's hard to identify any that look like they came out differently than they would have without Loper Bright. So, for example, the Title IX decisions, you look at the opinion, you look at the judge, that would come out the same way. Loper Bright just was an intervening precedent, and so it was thrown in as well. So it will take time. There are folks, Chris Walker, who I've co-authored some stuff with, has done some empirical work, some other folks have. It'll take time before we have the volume of data to see. I don't think Loper Bright, though, is going to increase the volume of litigation because all major rules are challenged anyway. The case that Rachel mentioned before, Corner Post, will increase litigation, but the caveat there is a lot of the really big statutes have their own statutes of limitations or statutes of repose, which apply and are not affected by that decision. So Clean Air Act, for example, very rigid statute of repose. So Clean Air Act rules aren't going to be affected by Corner Post. But Corner Post will increase litigation, and presumably probably in a couple years, that should be measurable. The effect of Loper Bright is going to require being analyses of the opinions themselves and disentangling what are kind of the pro forma citations to Loper Bright and what are decisions in which it appears as if Loper Bright actually shifted the strength of the competing arguments. And that'll probably take a little longer and more data points and a lot deeper analysis.
One thing I would add, I don't know if this was mentioned before or not, but as I'm sure a lot of people here know, the Supreme Court hasn't relied on Chevron for almost a decade. So that's an important kind of baseline setting for thinking about the impact. Lower courts may be a different story. I do think that agencies are not going to be able to do this sort of statute searching thing. That's a sort of immediate change, but how that actually plays out, it's obviously more complicated. What I'm particularly interested to see is what perverse outcomes might result from this. We've talked about how, Chevron itself has generated outcomes that no one really anticipated, and that took time, and so I think, we can think of other examples too, about what courts have decided about what agencies have to do, what kinds of rationales they can use, what kinds of evidence they can appeal to, can change the way agencies operate in ways that can be kind of surprising and unexpected and not always good. So that I'm not saying that will happen. I just am saying that that's an interesting question to raise and something to keep an eye on within different agencies, how they will over time adapt, what kinds of practices they'll adopt in trying to sort through what this really post-Chevron world looks like in practice. And that we don't know, I think, and it will take time to find out.
Yeah, you've been very patient.
Thank you so much for this panel. I wanted to get your take, mainly Professor Adler, but anyone else, on whether respect under Skidmore is kind of a backdoor way for judges to reach the same outcome as they would have reached under Chevron, but not call it Chevron. And I think the Kagan dissent somewhat alludes to it. She makes the argument that if judges have a hard time determining when to afford deference, they'll have a hard time determining whether an agency deserves respect. So I'd like to get your thoughts on that. Thank you.
There's, the pressure on judges to recognize that they're generalists and the agencies are not is going to be there either way, right? If you just want to model the behavior of judges, do I spend an extra, couple days or hours really trying to figure out how these provisions in this awkwardly worded statute fit together, or do I trust the word of the people that have to deal with it every day? That incentive is going to be there no matter what. But the shift from Chevron back to Skidmore, or a variant of Skidmore, what some people used to call Skidmore weight, I think under this opinion is better characterized as respect, privileges certain sorts of arguments on the agency's behalf. And so I think what judges are going to be doing, and again, this is what courts did from the passage of the Administrative Procedure Act up through whenever it was in the late 80s, where Chevron was recognized as having created something new, which again, as I noted before, was several years after Chevron itself. This is what courts did. And they looked for, how technical is the question at issue? To what extent is this a long-standing, consistent agency interpretation? To what extent was it contemporaneous with the statute's enactment? There are all sorts of things that make the agency's authority more persuasive than it would otherwise be. And I think courts are going to lean into that. And I think that reinforces the time thing that came up before about how the more innovative and aggressive the agency is acting, this analysis really makes that a much harder sell by the agency. Whereas the more kind of traditional and run-of-the-mill, the more like, okay, this is business as usual, there's no reason to really revisit that. I think that's the dynamic that comes up. But as you noted, just as we used to fight over, well, how difficult or unclear does a statute have to be before you characterize it as ambiguous to get to step two, right? That was always a gray zone. There's a gray zone here too. It's in a slightly different place. But yeah, there are going to be a bunch of cases where it's muddy, and there are reasons why we would expect judges in a lot of those cases to say, I'm not going to disrupt the agency.
Could I say something about that question as well? I think it may be taken in a slightly different direction. I don't think it's at odds with what you say there, but I think the respect versus deference distinction is very interesting and important to the majority opinion, and maybe has gotten short shrift a little bit in the kind of wider discussion about Loper Bright. What Chief Justice Roberts says is that essentially respect is replacing deference, and there's one way you can sort of be dismissive about that and say, well, okay, what does respect really mean? On the other hand, particularly when it comes to the issue of expertise, what the court is saying is, if technical expertise is needed to interpret a statute, well, it's not bereft of expertise. Chief Justice Roberts may not be a technical expert, but neither are many of the people in the EPA or whatever other agency, by the way, right? What can a judge do? Well, look at, for one, what the agency says. And in fact, the decision requires the court to do that. It just requires that the court not require itself the default to that. And so I think that's an important caveat, right, in how we think about the impact that this decision will have, that I'm sure courts not only can, but will avail themselves of that often. Maybe it's because they just find the subject matter kind of mind-numbing, but it's also a very reasonable place to start if you're trying to integrate technical expertise into statutory interpretation. And I think there's also an interesting analog to think about with Congress, right, where Congress, as we've talked about a lot today, doesn't have the same amount of technical expertise as agencies. But what do? They seek that expertise elsewhere, maybe too much, but one of the first things they do is ask agencies. Frequently, agencies write the statutes, or at least play a big role in that. One way is maybe a little provocative way to put it, but one way to think about what Chevron did, if you put it analogously to Congress, it would be not just allowing Congress to consult agencies, but requiring them to default to what the agencies say the statute should be. And what the court is essentially saying in Loper is, we can't have, I think Robert says, like a mechanical procedure. He just defaults to that. But it doesn't mean that the courts can't actually consider, and in fact, they have to consider what the agency interpretations are.
And Rachel, do you want to add to that or make any closing remarks? Yeah. So we're actually out of time, but thank you so much for spending your afternoon with us, and I hope you learned a lot.